What does this now mean for your client and the operation of the Caribbean International Brewery? And what other form of redress would you guys be seeking at this juncture?
Well, remember, of course, he's now gotten back the money, and he got back the money which had been held in an interest-bearing account. So he got it back with interest. But you will recall that when we were in front of the magistrate and I was interviewed by the media on various occasions, I maintained that once we were able to win in the High Court, that would open the door to an additional suit now for damages. And this is where we find ourselves. In other words, getting back the money is excellent, but not enough, because for the 6 months or so that the money was held improperly, as the High Court has now determined, Mr. Shin and the brewery were without that working capital. Also, because of the tremendous reputational harm suffered when that money was seized and it was continued to be detained against, as the court has now found, all the rules and authorities, Mr. Shin and the brewery found that a large majority of their distributors, of their products, of the beer in particular, cut them off, saying, look, we can't afford to represent you any further because you are in trouble with the FIU, you are in trouble with the authorities. There was talk of money laundering, all that sort of stuff. And so it was as a direct consequence of what was done, which has now been found to be entirely legal, that he suffered harm above and beyond just the being deprived of his $3.1 million for 6 months or 9 months or however long that was. So that is where the question of a suit, a claim for damages, will now come in.